numbers which is on your screen. We'll all collate them and place it before the distinguished panelists for this evening to respond to all your questions. Only request I have is please address your question relevant to the topic today so that it could be a focused response to all your questions. And before I call upon the speakers, all of them are already logged in and we have got some outstanding panelists. Let me tell you what's happening in MMA quickly so that you don't miss watching them. We have lined up some outstanding programs next 2 months. Coming soon is the 28th of August. We have stock market, war value or what, and it's a very, very good event. And we got some outstanding panel. Ganesh Jayaraman is a managing director of Advent Stock, and Sunil Subramaniam, Sundaram Asset Management. Nishit Master is Axis Securities, and also Vidya Bala will be moderating. She is from Prime Minister's Cell. Then on 31st August, we have an event jointly with International Advertisement Association. It's a talk on voice of change, gender portrayal from 30 seconds to 3 hours. We got some, again, outstanding. Mega Tata will be moderating the session. We have a very good panel, so please not to miss. The big panel, I'm not taking away time. You just log into our website, you can watch them. On 4th September, we have Startup India Opportunities and Excitement. Dr. Samvad Ghosh, CEO of IIT Madras Incubation Cell, leading the conversation with 2 outstanding couple in business. Prabhu Rajagopal, Professor of IIT Madras, and also Mr. Manu Iyer, Founder, Managing Director of Blue Hill Capital, is also joining us. And it's an outstanding event happening on 4th September. On 15th September, we have Vicky jointly with Flo, talk on Touch the Sky and Beyond. 3 outstanding women achievers who is going to be coming and sharing their insights, how they have done what others have dared to do it. Actually, please do come and watch this. Then on 16th of September, we have one of the flagship event of MMA, Kevin Care MMA Chinni Kitchen Innovation Award. This time it's happening on 16th September at IIT Research Park Auditorium at 6 o'clock. Do come, and the chief guest for the evening is Mr. Suresh Narayanan, Chairman and Managing Director of Nestle. We already gone all over India, film and outstanding. The jury is meeting day after tomorrow to select the best 3 outstanding innovators for the year. This is one of a beautiful, wonderful event. If you've not seen it before, I really urge upon you. All those who are watching online, even this event will be live. All our events, what I'm telling is on live on all our channels. And if you missed it on the same day, not to worry, it's available. Recording will be available for you to watch it whenever it's convenient for you. 28th September, we have an event on Startup India Opportunities and Excitement. Devanshu Kumar from Solinas, along with Swastik Sarod and Sujata Srinivasan will be leading the conversation. Then on success story, how it was done. Again, this person I'll walk miles to listen to him is Mr. Mahadevan. You all know him as the Heartbeat Mahadevan. Brilliant mind from teacher to become a great entrepreneur by taking some of the best brands internationally, including Sarana Bhavan, all over the world. So come and listen to him, how he's really turned around his business. Then we have 22nd Read and Grow. Then on 28th, again, outstanding event, Mr. Ajay Chaudhary, co-founder of FCL, is going to come and talk to us on very, very important theme. Do come. We have the theme. Again, we have very, very high-profile panel. Then on 30th September, Busting the Management Myth by Peter D. Jagger is a thing along with him. We also have an outstanding speaker along with him. I know how many of you know Ashok Sutha. Ashok Sutha is the founder of Mindtree. So we have lined up some outstanding speakers for you to come and think. Only thing is you have to listen. If you don't listen live, at least listen online. If you don't want to listen online, at least watch the recording. If you don't want to watch on recording, it's all published in our digital magazine of MMA with embedded video. Read them. I think beyond this, MMA cannot do anything to make you a smart management leader. So this is what we can do. Thank you so much. Coming today's event, Data Protection Act 2023. The day act, the bill has become an act, and I had a chat with Navi. Navi right away said, yes, you must do this quickly. And anything on data security, cyber security, we look up to Navi with a lot of reference. One of the brilliant minds today in India and great supporter of MMA. And we have a very brilliant panel, ladies and gentlemen. Put your hand together to welcome the people who have joined us online, offline for this evening. We have Vijayashankar, popularly known as Navi. He's a data governance and data protection consultant, chairman, DVPI. Very warm welcome to Mr. Navi. Pleasure to have you with us. Then we have a very, very high-profile panelist. I'll shortly introduce them. Anirban Ghosh is a senior manager, data compliance, India, AMEA, BAT India, and he joined us from Kolkata. Very warm welcome to Mr. Anirban. And we have Avinash is the Dean of Manipal Law School from Bangalore. Dr. Avinash, very warm welcome to you. It's a pleasure to have you with us online. Then Savitha, Kesav, Jagadeesan, Senior Partner Kochhar is joining us in person. May I please join us on stage, madam. And we also have Rohan K George, Partner, Samvad Partners. He's joined us online. Very warm welcome to you, Mr. Rohan. We also have with us Mr. Mahesh Balakrishnan, Associate Director, Security Governance Complaints from Unipore. And Mr. Mahesh, please, request you to please come and join us online. We also have the founder of MapTech Consulting and also President of DPPI Chennai chapter, Mr. Sridhar. Please, Sridhar, come. Good to have you with us as a partner. And this is you have seen what an outstanding panel we have today for this evening. It's going to be a feast on Data Protection Act. At the end of the day, I'm quite sure whether you protect yourself or not, you will protect your data. I can assure you that. And let me have the privilege of introducing the distinguished panelists for this evening very briefly so that you understand the people whom we are going to be listening. Let me start with Navi, popularly known as Vijayashankar. He specializes in consultancy-related regulatory compliances in the area of ITA 2008 and a thought leader who pioneered several concepts in cyber jurisprudence and introduced the service of cyber evidence and online dispute resolution, etc. Now working on developing debate on how the classical cyber law thinking needs to be modified consequent to the emerging technologies such as artificial intelligence and quantum computer. Once again, very warm to you, Navi. You are eagerly looking forward to hearing your inspiring thoughts. Then we have Dr. Avinash. He worked with, he's the Dean of Manipal Law School, Bangalore, and he specializes in the area of intellectual property right, competition law, legal regulations, AI, robotics, cyber, other emerging technologies. He has been selected as antitrust fellow in prestigious program, International Visitor Leadership Program, IVLP, by the Department of State of United States in the year 2015. Once again, very warm welcome to Dr. Avinash. Then we also have with us Savitha Kesav Jagadeesan, Senior Partner, joined us in person here. She enrolled to the bar from the Council from Maharashtra and Goa in 1997, a member of the Supreme Court Bar Association since year 2001, a graduate of NLSCIU from Bangalore, one of the premier National Law Institute, and specialized in transaction negotiations, corporate advisory, service of the key areas, and are also specialized in cybercrime and security issues. And further area of expertise are corporate law, commercial law, Indian investment strategies, and much more. We are very warm welcome to you, Savitha. And we also have with us Mr. Rohan K George. He joined us on online. Mr. Rohan is a partner from Samvad Partners and is an intellectual property specialist, information technology practice at Samvad. He also handles dispute resolution matters in Chennai. Rohan has an extensive experience in the field of intellectual property, information technology, and also in media law. And Rohan is a VA LLB honors from NALSR University, Hyderabad, and also LM from Columbia University, USA. Very warm welcome to you, Mr. Rohan. Let me have the pleasure of introducing Mahesh Balakrishnan. Mahesh is Associate Director of Securities Governance Compliance Unipore. Mahesh has joined us in person here, and he specializes in the area of information security of large global organizations. And is today one of the constant instant information exchange as a security governance and compliance. He plays a very, very active role bridging the gap between today's technology and tomorrow's innovations to ensure information assets and IT systems and technologies are adequately protected. He handles the privacy and information security with diligence and also third-party risk. He's also associate with ISACA, Board of Directors, Chennai chapters, and providing valued technical information. He's also actively engaged in the industry to maintain the peer group dialogues, develop partnerships, share subject matters expertise. Ladies and gentlemen, this is one of the outstanding panelists we have. Big round of warm applause to our distinguished panelists this evening. And I'm quite sure you're going to have a thing because this has been discussed for a very, very long time. From bill, it has become an act. There's a lot of news, a lot of cuttings, a lot of information coming. Many people are confusing. That's why we choose a panel which is very, very diverse, and they're all knowledge, experience, down in their own field. As much as you, without any further ado, I'm also looking forward to listening to them. Over to you, Navi. Thank you once again to every panelist. Navi, over to you.
Thank you, Vijay Kumar. It is always a privilege to be associated with MMA programs. Often, of course, I take the pleasure of coming to their premises. This time, of course, I am connected online. But I'm happy that there are, of course, Mahesh Balakrishnan and Savitha present there along with Sridhar. Sridhar is the chapter president for Chennai for FDPPI. And I welcome all of you panelists, including Dr. Anirban Ghosh, who is the chapter president for FDPPI in Kolkata. Rohan George is one of our senior supporting members of FDPPI from Chennai, and Professor Avinash Dhadhich, the Dean of Manipal Law School, with whom FDPPI is having a MOU for conducting various programs. And it is always a pleasure to discuss something new. Okay, Data Protection Act is fresh from the oven kind of a thing. Okay, it has just been signed on 11th of August, and all of us have been on the moon as far as the data protection is concerned, because we have been waiting for last several years, and suddenly over a period of a week, the law actually was passed. So we are all very happy about this development, because India needed a law of this nature. Whatever may be the deficiencies of the act, at least we now have an act which can always be improved. Okay, so today, with all these distinguished panel members, I don't have to say much as an introduction. We will straight away go and start talking to our panel members one by one and try to extract from them their wisdom on this act, so that the audience who are present there physically, as well as those who are present, say online, will get a complete overview of Data Protection Act as it has been passed. You will be having some questions. I request you to pass on your questions to somebody in MMA there. They can perhaps post it in the chat room so that we can directly see that, or one of them can perhaps read it out at the appropriate time, so that we would have given opportunities for the people to raise questions. Okay, with this introduction, let us start off. We have in the panel Rohan George, who is an advocate, Savitha, who is an advocate, and Mr. Avinash, who is an advocate and an academician. Avinash also has experience as a Supreme Court advocate, as well as having worked in EY. So he has got both the industry experience as well as the legal experience, and now, of course, teaching. In Mahesh and Anirban, we have two people who are practicing data protection people. So we will be able to get some information from them about the practicing things. If it is necessary, I will also take the assistance of Sridhar, and I will also add whatever I can add. Okay. Now, we call this as the Digital Personal Data Protection Act. Okay. Now, let us start with that. I think what is the applicability of this particular act, and why is it called Digital Personal Data Protection Act? I think we will start with Mr. Rohan. What are your views, Rohan? Why is it called Digital Personal Data Protection Act?
Thank you, sir. Yes, that's a very good observation regarding the act, obviously from an expert such as yourself, because all the previous iterations of data protection bills and legislations we have seen prior to the 2022 draft bill which came out did not make a distinction between digital data and non-digital data, and also did not distinguish between automated processing and non-automated processing of data. However, this act, allow me to clarify, very clearly limits its applicability to data which is collected by an automated, to digital personal data, which is personal data in the digital form, or which becomes collected, and to data which is collected by an automated process, basically. That is basically any process capable of operating automatically. This is actually a very interesting situation for a country such as India, because yes, while we are moving deeper and deeper into a purely digital governance system, so much of India's record keeping and documentation. And that too, yes, so much of personal data is in non-digital form. There are many organizations which still prefer to keep paper registers and records. And now we have two standards for the protection of data and more importantly, for protection of individual privacy in situations where the data is digitized versus situations where the data is remaining undigitized. And to my mind, I would say this raises a concern also for me, because it actually disincentivizes digitization. Because a person knows that as long as they are outside of the digitization parameters, they are effectively outside of the applicability of the Act itself. There are, of course, various other important ways in which the Act itself restricts applicability. It focuses on geographical limitation, and a very interesting section of the Act which I'd like to highlight, which is of interest, to industry in general, I would presume, is a partial exemption from applicability, which is built in the form of what I call the outsourcing exception, basically.
We'll come to that, Rohan, later. Okay, we'll go step by step so that people will be able to follow the sequence. Now I will go to Savitha. Savitha, now this Puttaswamy judgment we consider as the starting point for all this legislation related to privacy. Now, how do you think this Digital Personal Data Act is addressing the concerns which was expressed by the Puttaswamy judgment?
Quite so, rightly so, because the Puttaswamy judgment, correctly, what it did essentially was it upheld the right to privacy. So that was one of the foremost things. So I'm just bringing a little bit of context here. So the Puttaswamy judgment essentially dealt with the Aadhaar provisions. So without going into that specificity, it did, in a majority view, hold right to privacy to be an inherent fundamental right of an Indian. And it actually aligned itself to right to life and liberty also. So both 19 and 21 was essentially upheld. Now, this particular, what you call act that has come forth, essentially deals specifically with personal data. So if you see the distinction that it has drawn from what Section 43A, which is right now a prevalent data protection that we could essentially call it, the distinction it has drawn is that this deals with purely personal data. So therefore, that Puttaswamy judgment essentially got reinforced with this act. But where essentially there is a cause of concern is the exemption provisions that have been provided in the Chapter 3.
No, we will come back. We will come back to the exemptions because that is more detailed kind of thing. Okay, let us now stick to the basics of digital personal data. Okay, so we call that as digital because it is applicable to data collected in digital form within India, and data which is collected physically in physical form but digitized by entering it into the computer. So that is a digital.
Yeah, the manual formats.
A manual collection, but digitized. Okay, yes. So these are the two things which are being covered here. And of course, the Puttaswamy judgment spoke about information privacy. This particular act is trying to focus on that information privacy. And some of the government has felt that non-information privacy is not a serious concern for the community. Whatever issues are there, concerns are there, the existing laws will take care of it. This is like the low-hanging fruit kind of a thing. The digital personal data, which is of a concern, we will address that. Okay, so it distinguished digital from non-digital. Now, personal data, it says, Professor Avinash, can you unmute yourself so that when it says personal data, how do we see the applicability to whatever is not personal? How do we distinguish? We are a company, let us say I am a company managing information of my customers. I have various business clients. Now, which information is considered as personal data according to you, Professor?
Yeah, so I think it depends on the interpretation, how we define data and how we define the personal dimension of the data. So first we need to understand that the objective of this law when it talks about the personal digital data. So when it was said by a British mathematician that data is the new oil in 2006, so his objective was that data is useless just like a raw oil. It has to be refined, it has to be converted into a particular product, and that final product has some commercial value. So in the same way, when you're talking about the personal data or non-personal data, you need to understand that what could be the final objective or what could be the business dimension of that particular data. Okay, because you need to see this thing from the two dimension, one from the customer's point of view or from the principal's point of view, the other from the company's point of view. So for me as an individual, everything is personal, but maybe for a company's point of view, everything is not personal. There are so many there's a lot of information which is available in public domain. So I think it depends on the interpretation, but what I believe that you need to see the objective and the users of data for the commercial purposes. I think that will give some guidelines to understand the personal dimension of the data.
Okay. Of course, if we look at the definitions section of the Act, it says if there is a data set and if you can identify an individual out of that data set, we call that as the personal data by definition. There is another part in the definition which says a person means a Hindu and includes HUF, something else, business or juridical person, and etc. Now, so many of the people are confused. Who is this person which is there as HUF and other kind of entities, and does information about those juridical entities are also covered in terms of protection, or as protection is limited to the individual, whereas obligation to protect is on the organizations. Maybe I think Mahesh can add his views on this, though it is not purely technical, it is a legal this thing, but still I would like to get the views from Mahesh. Yeah.
Good evening, everyone. My organization says leave us alone as a disclaimer, right? Right to privacy. But then again, thank you for that question, Navi. One of the things is where do we get the data from? One question. We are talking about all the other clauses in terms of personal definition. But if you look at the definition within that act, the last one clearly says a juristic, it brings about the juristic aspects of it, right? So somewhere the processing in terms of artificial intelligence or something along those lines comes in. So one question which we ask ourselves is, where do we get the data from? Okay. Once we know where do we get the data from, do we know, are we using it for the defined purposes, not only for complementary purposes? So the very first question which we are asking ourselves from the personal data, right, is where do we get the data from? At this point of time, we will continue with the conversations now. So I'll just stop it at where do we get the data from?
So you are looking at the source of the data. Now, Anirban, now I have raised one question and I see a difference between the legal people and the technical people. I am using person in two different dimensions. A person whose privacy has to be protected by protecting in some way or managing his personal data. That is one dimension. Other is an organization which is collecting the personal data, which is also a subject of this act. This act applies to an individual. Act also applies to an organization. But the way it applies is, for the individual, it tries to protect his personal data in a particular manner. For the organization, it says you have an obligation. If you don't do it, I will be putting 250 crores or 500 crores fine. So this dimension, can you just clarify how At the same time, we can say Act is applicable for individuals, Act is also applicable for companies. Okay, so that needs to be clarified because we have in the business, we have got proprietary concerns, okay, which will have personal information in business transactions. We have got partnership firms, and we have got transactional data between a company and an individual, which is also a mix of personal data and what should be considered as business data. So when you want to actually classify data in an organization as the first step towards compliance, my first question which arises as a data manager is, which are the data which I can push and say this is personal data, which are not personal data? What about this mixed data, a transaction data? I have got an invoice. Invoice says, say Sridhar of MapTech also, you say, but Sridhar is still a personal name, his address is there. So invoice has got personal data, but it belongs to my company because he has purchased something from me. I have collected some money or something like that. So that data, should I consider as personal data or should I consider as business data, and then set up my computing systems? Yeah, Anirban.
Thanks, Navi, sir. So I think, sir just spoke previous to me, highlighted a very important point, identify the source of data. So I think the Indian companies are really in hurry, to understand this act or to implement this act. But what is really important, sir, is to understand where is my data, okay, and where is my data. And I'm talking from a organization standpoint, sir, not an individual standpoint. So to understand where is my data, definitely source is one of them. The second one is the type, define the type. Third one, what am I doing with the data? Am I just keeping it? Am I giving it to a third party? Am I processing it? So this is called a pure data mapping with, exercise that we go ahead and need to perform on a data. And this is
Please tell me
first,
first.
every organization
Please tell
should
me first,
do a
how do
data
I
mapping exercise to
classify a
understand
data?
the data.
No, let us focus on how do we classify a data as personal, non-personal. I gave you the example of a transaction data. Okay, and the Act at some point of time uses business contact information of a DPO should be published. So what is the business contact information and personal contact information of the DPO? Okay, Rohan now wants to say something.
Yes, sir. Sorry for butting in. I think that the main point here is to, you had a specific question about the distinction between a person and an individual. So I mean, here this is a very lawyerly distinction, but the Act creates two kinds of actors, basically. One is the so-called person who is doing the processing of data, which can include all kinds of persons, including individuals.
Yeah.
And then it creates a category of personal data, which is a data about an individual. So that is very clearly focused on individuals.
Yes.
The other main concern, which I feel is something which will be an interesting point to see how case law builds up, is the individual must be identifiable by or in relation to such data. Okay. So when a person is identifiable by data, that is a fairly direct correlation, which you can very easily establish. But when a person is identifiable in relation to data, that creates a very interesting kind of situation where you have certain data points which need not necessarily directly identify a person, but when combined with others, will have the effect of being able to identify that person within a certain range. So I think it is again a vaguer definition of personal data than in previous iterations of the Act, but it at least allows us to understand that personal data does not have to only mean name, address, email, ID, and such like, but can include much more sophisticated data points. So that's something to take.
Okay, thank you for clarifying this difference between a person who is the subject matter of protection and a person who is the processor of the data. Okay, now of course we will go further. One of the things which we are seeing in this particular Act is they have defined the roles of a person who decides about the purpose and means of finance as a data means of processing as a data fiduciary, and they also make a reference to somebody called a significant data fiduciary. On the other hand, Section 43 capital A of ITA 2000 spoke of something called sensitive personal information. And even if you look at GDPR and other these things, which might have called it as a special category or whatever is that, so basically sensitive. Organizations which are processing a large quantity of sensitive personal information are always considered as a high risk business. And if you want to call somebody a significant, the significance should be based on the sensitivity of information. Now, Savitha, can you tell me how does this act identify a significant data fiduciary? What is the criteria for that?
So there are quite a few criteria that they've essentially set out for a significant data fiduciary. So one of the most prominent ones is what kind of data essentially is being collected. So that is one of the things. So I'm just looking through my notes so I don't miss out anything.
Yeah. So yeah, of course, volume and sensitivity is one criteria.
Yeah.
Okay.
So things that they have essentially put out is that the criteria that is set out for determining it, that is the volume of the data, then what risk of rights that are essentially affecting it.
Yeah.
So of the country, then aspects of what do you call the territoriality of that data. All that is essentially considered when you differentiate between a data fiduciary and a significant data fiduciary. So long as a significant data fiduciary has all these aspects essentially getting tick marked, they are set aside from what a data fiduciary essentially is. So anybody dealing with the personal data, anybody using a data processing agent will fall under a data fiduciary. But anybody who's using significant amount of data, anybody who's using a significant amount of data, and that data essentially is affecting the territoriality or the sovereignty, those aspects makes them essentially a significant data fiduciary.
Okay. Mr. Anirban, now if an organization is considered a significant data fiduciary, what does the obligations or additional obligations which will be required for that particular type of data fiduciary?
Three extra obligations compared to, fiduciary, and if you consider it as a significant one. Number one, you need to appoint a data protection officer or DPO who will be based out of India, and his or her contact details will be published on the website of the organization. The second one, the organization need to implement the infrastructure to do data privacy impact assessment for any change within the organization in regards to processing or collecting of personal data, along with any new project or technology that has been built which will using or processing personal data. And the third one is to appoint an independent auditor to get an audit done of all the processing activities or all the compliance against the Digital Personal Data Protection Act 2023. But how frequent or the frequency of the audit is yet to be announced in due course by the central government. Yes,
okay.
So these are three.
And several notifications will come. So from time to time, we may be saying that it will be specified or something like that. Mahesh, we will come to another important aspect, which is about the category of data fiduciaries, which they are calling as consent managers. Now, what is this consent manager? What kind of data fiduciary is he? Can you just throw in your ideas? Because this is a kind of controversial topic of discussion to some extent, but let me have your view about it. Yeah.
Sir, I'll have to thank one of my colleagues from the board of ISACA for bringing this up, Jayashree. She and I had a very good debate about consent management. Okay, and she's here as well. One of the things about consent manager is how do we interpret as an organization on consent manager? Very simple. Do I go ahead, appoint a consent manager within the organization? Point number one, right? But here the question which we need to go in and ask is the trust factor between the data principal and the organization which collects the data. So can the organization appoint a consent manager? Point number one. Two, are we taking it to third parties, like how banks do the KYC management? So typically, when we looked at it and we are about to go ahead and implement, most of the things come about as we would have a third party which manages these consent on behalf of the data fiduciaries as well as the data principals, and they report to the board.
You use the word on behalf of the data fiduciary. I want Rohan to actually explain what is his concept of this consent manager. You are on mute. Okay, what is your concept of a consent manager? Is he acting on behalf of a data fiduciary or in any other capacity? You are still on mute. Yeah.
So is this question addressed to me?
Yeah.
Noted. No, so I think that one of the key obligations of a data fiduciary is to inform the data principal of the right to appoint a consent manager, basically. And if I remember correctly,
that is in the notice or general awareness. Okay, fine.
So the implication there is that the consent manager can be a layer between the data fiduciary and the data principal,
Yes.
but the data principal has the right to appoint any consent manager they choose. Obviously, the data fiduciary can make it easier and more convenient for the data principal to be able to operate through certain consent managers. But ultimately, I think the Act seems to put in place a choice regime for the data principal, by which the data principal ultimately has the option to make that choice. So I think from a compliance perspective, that's worth keeping in mind also. Yeah.
I agree with Rohan on that also, because it's very clear as far as the data, as far as consent managers are concerned, that it can essentially be somebody that the principal, data principal can approach in order to provide that consent. So we can also have independent consent managers essentially being set up, and maybe greater clarity would essentially come in once the rules are brought in. So,
but one of the other things which I wanted to go and bring about is when there is a third party consent managers, they become significant data fiduciaries as well. So who's going to manage them? And that's a question.
Okay. Yeah, Dr. Avinash, add your thoughts on to this.
No, consent manager, I think it's not a very new concept. We are already doing in the financial sector. I think there are few questions which we need to ask right now. How many players would be allowed by the government? What would be their market power in this situation? Because here we are going to deal with millions and billions of requests by the different people, organizations. So we need to see the power of the consent manager. See, the entire objective of this data privacy law, data protection law, is to protect the privacy of the people, or give some sense of privacy. So when we are appointing big consent managers, what would be their responsibility? Definitely, it will be cleared by subsequent notification and circulars. But I think their responsibility will be very important. As my previous colleague mentioned, this thing that when they will become the significant fiduciary, who is going to control them? So the idea is that the more and more things, if you are moving to the government side, because we should not forget that the government will also be a significant fiduciary, data fiduciary in this under this act. So I think there is a conflict of interest situation between the consent manager and the significant data fiduciary. Who is going to pay them? What would be their relationship with the significant data fiduciary and vis-a-vis with the government? So these are the questions which comes to my mind right now.
See, what I see in the act is the consent manager will be a special kind of data fiduciary. He will be registered, and there will be a set of guidelines. The guidelines for a consent manager will be exclusively defining what are his roles and responsibilities. But one thing they have mentioned is that he will be representing the data principal, not the data fiduciary, which means that he will be acting as a trustee. Now, the consent manager, which we are presently aware of in the financial sector, is a technology platform it is working more like an intermediary, like an ISP. The data comes from one end, it goes to the other end. This intermediary, which is called the consent manager, doesn't have access to or visibility to the data of a person. Whereas what this act envisages is that the person, whoever you call as a consent manager, which cannot, in my view, be a individual, it has to be a big organization. If it is an organization, they may still have visibility to the data, and like a data fiduciary who has a visibility to personal data, but he is expected to protect it by his own method. This particular consent manager also needs to take the responsibility for managing a visible personal data. And if you look at the qualifications or criteria, it talks about financial prospect of a particular consent manager, which means that the government may say that they should have a minimum capital base of 5 crores, minimum net worth of 50 crores, something like that, like they have done in the case of the certifying authorities in digital certificate area in Information Technology Act. This will be a new cadre of the, say, business, which will be coming up. We do not know, because this kind of a thing is not there in GDPR or US or something like that. In US, sometimes we use terminology data broker, but data broker is a purely a person, kind of a business entity. There is no fiduciary trustee kind of a thing there, as much as we find in the Indian kind of a position. So it's a very unique proposition. It will, in my view, will be something like the certifying authorities in the digital signature system, and they will appoint registration authorities or RAs who will have a face-to-face relationship with the data principals, so that if it's a rural area, if they need to be taught about what is privacy. Now, of course, notice has to be in 22 languages, but still the concept of what is there in the notice may have to be explained. So this person will act as an intermediary between the data principal and the data fiduciary, and maybe he may give many value-added services. So I am looking at this data fiduciary being one step ahead of the current consent managers who are technology platforms which are there in the ITA 2000. More than this, I think we will look at it later, unless Anirban has got any specific.
But Navi sir, what would be the economics of this consent manager? Like, if he's charging something, the transaction cost itself will defeat the purpose of this particular act.
Possible. Say, it's like if I am going to use a bank for, let us say, safe deposit locker, I pay money to put my things there. No? So like that, if the data principals think that they need to protect their data and they themselves cannot do it, they want somebody to assist, that will be this data consent manager. Now, how much he will collect from the data principal, whether it will be nominal or per transaction basis, like say Aadhaar has got this, what is that, proxy IDs they give, no, virtual Aadhaar. Of course, Aadhaar is a government this thing, so they don't charge. But suppose that was a business, that there is something which I want to protect, but somebody is giving me a anonymization service or pseudonymization service, whereby I can convert my Aadhaar into a virtual Aadhaar so that I am protected. I may be willing to pay a few paise for every such transaction, is a thought. Okay. So consent manager has to devise that kind of revenue models. Now, whether he will be able to get some revenue from the fiduciary, now he should not develop any relationship which will introduce some conflict in the interest. But without conflict, it may be possible for him to charge certain fees at the other end. Okay, like providing a service to Zomato. Okay, now he may say that I will do the KYC of the people. I take a financial this thing where KYC is very important. Now, if I have to do KYC, I have to spend 200 rupees or 250 rupees per client. Now, this consent manager can have KYC done set of personal data. He can build a million such sets, and then tell these companies that each time you don't have to take the money like civil. Now, civil and others, they charge money from the users, is it not? Like the financiers or something like that. So this particular organization also may charge the data fiduciaries, but not fall into the trap of a data fiduciary who says, I am giving you $1 million or rupees every year contract, so you have to do what I want. So as long as they can retain their independence, they may get paid perhaps from the data fiduciary side also. These are the things which intelligent business managers will have to think about and then design. Yeah, Mahesh wants to say something.
Now, one of the other things which I'm asking myself is, I'm a data fiduciary. Okay, can I go ahead and build a platform to manage the consents of our data principles? Simple question, a platform which I can. But here we are asking the consent management hinges on the data principles, on the trust which they build with the consent manager. I mean, many organizations which are startup can go ahead and build a platform for consent management, right? So how you use the word independence, right? So how independent can a data fiduciary be if they can go ahead and build a platform?
But there are two aspects to this. So when you look at the consent that is to be provided, the consent can be provided directly. Therefore, building a platform essentially is perfectly fine so long it is fulfilling the requirements that has to be provided, which is the notice and what requires to be given in the notice. It's fulfilling the requirement that you have to give the entire process. It's giving the requirement for the person giving the consent to understand withdrawal of consent. So long as your platform ticks all this, you can have that. The consent manager is essentially an in addition aspect that has been provided in order to enable it to make it easier for the data principal to provide that consent. So in case they don't want to use your platform or your notice, they can essentially use a consent manager to process, provide, and give in. And in fact, the consent manager can do this to a platform. That's
I have triggered a thought process on consent manager. We will leave it there because we will not be completing that. Say many people say only 44 sections are there. What is there to discuss? In fact, when we are doing a training, somebody was asking, what is there to train? Everything that people can read and understand, because minister also says it's a simple language. So we have eliminated lawyers. So there is no need for training or something like that. But as we have seen, we have not completed applicability and one aspect of the fiduciary classification, and we have already spent 45 minutes or something like that. So that is the depth of this particular act. If we go to it, you know, there are complexities. And if we are not able to understand this, penalties are there. Now, penalties may extend from 50 crores to 250 crores for different things like not reporting the data breach, or not having adequate safeguards, security safeguards, not having organizational policies and other things. Each of that can have an impact of 250 crores. If I don't know that I am a significant data fiduciary and therefore I don't appoint a DPO, so my classification error will lead to me not having a DPO, and therefore I am liable for the penalty. So if I don't classify me as a significant data fiduciary, for which actually guidelines have to come, then I will not be doing a DPIA. I will not appoint a data auditor. So classification will perhaps, if there is a mistake, it will have long-term consequences. So applicability, and similarly, when you talk of applicability, the question comes, this act says that it is applicable to digital personal data processed in India. Now, digital personal data processed in India need not necessarily be of only Indian citizens. It can be of somebody else also. It talks about being processed in India. That is covered. If data is processed outside India, but it is related to some business or services to Indian people, that is also covered. But if there is an Indian company which is doing some processing outside India, and if that data is not of Indian people, it is not covered under this act. So suppose I am a multinational who is having a setup in a foreign country, and that local data I am collecting, processing, and doing, I am exempted from that. Secondly, if in India, I am taking foreigners' data and processing it like a BPO does under a GDPR contract, I am exempted from that. So this particular act clearly focuses on data processed in India or processed from outside about the Indian business. So that way it is substantially different from GDPR. Rohan wants to say something on this.
Thank you, sir. I just wanted to point out just one point of clarification on that. Even the exemption given for processing of data of non-residents pursuant to a contract outside India doesn't exempt the entity from the entirety of the act. It exempts them from the obligations, but it does mention that they are still required to generally comply the act, and it requires them to maintain reasonable security standards and practices.
And right?
Yes.
Okay.
Yes.
Cross-border, three things.
Yes. It exempts them from cross-border. It exempts them from data principal rights, basically.
Yes.
Yeah.
Exemption is a limited exemption.
Yeah. That's
Exemption under Section 17 is not an absolute exemption. It is a limited exemption. Okay. Similarly, when you talk of the lawful basis of processing, our law focuses on consent. Consent being more or less absolutely essential. Consent based on a notice. Notice has to be in 22 languages. Of course, clear, concise, all that is there. Now, in that consent, we discussed the role of a consent manager. Okay. Then after having collected it, it has to be purpose oriented. So this only talks about purpose oriented, and unlike GDPR, it doesn't list out 5-6 elements, data minimization, etc., etc. It is all implied in the purpose, because if a purpose is over, you are perhaps not supposed to retain that data. So data retention minimization is ingrained in the purpose itself. Data minimization is also part of the purpose. You are collecting it for a purpose, therefore the purpose has to justify what you collect. So though not specifically mentioning data minimization, it more or less includes that in the purpose. But lawful basis basically is the consent, which is very important. But there also, there are certain legitimate users. Okay, there is a section on legitimate use, which set things where consent also may not be required. Say earlier we used to have something called deemed consent. Now they call that as legitimate consent. I think Savitha should open that section, okay? Because this is very important from compliance point of view. An organization, first thing I have to think is, am I exempted? If I am not exempted, at least am I coming under legitimate use? That will actually minimize my compliance requirements. So in terms of building a compliance by, say, you all used to using privacy by design. I have always been telling that we have to use compliance by design. I think this act has taken that suggestion of mine, and they talk about compliance. It doesn't say you have to protect the privacy of an individual. It only says if you are processing the digital data, please do this A, B, C, D, E. So it is compliance. So an organization has to develop compliance by design. And when we do that, this legitimate users list is important for us to look at. Now, I think since Savitha is one who is having the document in her hands, I think she should say what are the main things there. Then we can check with other panel members about their reactions to what is legitimate use. Yeah, please.
It's quite interesting, you know, so the number of legitimate uses that they have essentially put. But more importantly, I think it's the illustrations which make it very clear here that essentially whenever you have givens, put it simply, whenever they're giving the personal data and it's to be given to the data fiduciary for that specific use, then that is when the essentially that consent has to be given for that use only. So it has to be essentially specified. So when you're going into, let's say, so the illustration that they have provided here is basically of a pharmacy. So when you're entering the pharmacy, you're providing all your personal data, you acknowledge the receipt of that payment for the purchase, and then that data is essentially processed by the pharmacy and held on. So I think in India as such, it won't be so much applicable, because once that particular time you've gone to the pharmacy, you've given that data and finished, that ends the pharmacy's use of that particular data.
Pharmacy is only one example. Now
Yeah.
I ask other people like Mahesh or Anirban to give other use cases. Voluntary provision. Yeah, Mahesh, give me another example of voluntary other than pharmacy.
So, one question which one question which I wanted to go ahead and ask is, when we talk about providing the data, the legitimate interest is on whose side are we talking about? The data giver or the data receiver? Okay.
Again,
Okay.
I want you to focus this in GDPR.
Legitimate use.
Legitimate interest.
Right.
Here, use the term legitimate use. There could be some legal difference between the two. Okay.
So if I'm going to go ahead and classify that, assuming legitimate interest, right? Assuming in a technology organization, right? We go ahead and process the data. As you rightly said, one purpose, we go ahead, use the data for one purpose. Unless and until there is a complementary purpose, we are not supposed to go ahead and use that same data for a different purpose. The question is, are we stopping it? The other example which I can go ahead and think about is when you talk about personal data, non-personal data, right? We go ahead and anonymize the data. Once we anonymize it, it becomes a non-personal data. So what do we do with it? Information as a life cycle. Today, contractual compliance talks about receiving the data, storing, processing it, okay, and destroying it and giving it back to the organization in a structured or an unstructured format. So how do we process, how do we go about defining the legitimate uses? So to me, I always ask the question, legitimate for who actually?
Okay.
May I give an example?
So of course includes the mergers and acquisitions, employee-related processing, which are all corporate this thing, and it also includes the government-related law enforcement and. Okay, I think we are actually running short of time already. Just last question for the panel before we go to take audience questions. That is about this act talks about the duties of the data principle. One single line thought from some of you. This is again something new, which is not there in GDPR. What are the duties? Rohan, I think you start and tell me, what is this duty of a data principal? Why 10,000 rupees penalty can be imposed on him? Yeah, please tell me. You are on mute. Yeah.
Sir, I can actually, illustrate this duty with a particular scenario we faced where we were at least advising an Indian company with GDPR compliance, not officially, but at least coordinating it, because a new category of litigators has arisen in the EU, which is the data troll, basically. What that means is that there are people who specifically go out and hunt down flaws in data privacy compliance, maybe not maintaining a proper cookie policy or mentioning one thing and not covering another, and engage in serial litigation on that basis. And we do have to acknowledge, once you have a new compliance regime, you have people who will exploit from all sides, basically. And I think what this provision is doing here is sort of informing the data principle that what rights they have to be measured by duties, just as our constitution does. So in that context, the kind of duties which are there are, I think, mostly straightforward. Some are concerning. So, generally compliant with provisions of the laws are is fine. That is a very broad-based statement. Saying not to impersonate another person is also, I think, very valid. I don't think any person is entitled to or required to impersonate another person. Not suppressing one, I'll only mention one, which I think I'm concerned about. Okay, not to register a false grievance is understandable. A frivolous one is the word frivolous is a complicated word. And there I would anticipate a certain amount of concern, because you don't want a person who has genuine grievances having his classified as a frivolous.
Okay, I understand, but let us not think that DPP will be anti people. They are also perhaps responsible. Anirban, do you see any specific issue in this duties?
No, I think it's a culturally very well defined. We know what are the challenges we might get from a data principle side, and the data fiduciaries or the organization need some sort of safeguard. So I think this is very beautifully being taken care of, to ensure that people are not raising unnecessary DSARs or unnecessary grievances, and company have to spend a lot of time and effort on those. So yeah, I think it's very well defined, keeping the culture in mind, especially.
Okay,
Can
good.
Can I just add one thing? So when it comes to the duties, one of the things that is there that a data principal must keep in mind is never to give false information. So I'm just roughly summing up all the various things one has to keep, or material information. So a lot of us essentially, when we provide information on certain sites, I mean, I've done it many times. I don't give my exact information because I don't want anybody to be collecting that information. So now this becomes a cause of concern for me, because I'd like to explore sites, but I don't want to give my data, but they won't allow me entry unless I give data. So I feel that's something, I mean, why do you have to give duties to the data principal? It's essentially about them.
Last word to Avinash.
No, I think I agree with Savitha, because when we are trying to develop a culture of privacy of data, privacy culture, and at the same time we are saying that, okay, 10,000 rupees can be imposed on you because if the board finds that your complaint is not genuine one. Now the question arises that once you impose 10,000, then other types of legal liability may also arise. Then the big companies may start different type of litigation against that particular person or the organization. Okay, so the point is that I really can't understand that at this point why we are trying to create a huge terror in the minds of the people that if I go against a big company, I may be also prosecuted. It may create a lot of misinformation.
Okay.
10,000 is not a big amount, but it may create a lot of misinformation among the people and the civil society, and maybe they don't want to go under this particular law.
Okay. Anyway, that is for the government to DPP to ensure that will not happen. I think we will now at least give some time for the audience questions to be taken up. I request Captain Vijay to read out if any questions are there.
Yeah, go ahead.
Can you hear me? Hello. So my name is Shankar. I work with Chola MS General Insurance. I'm the Chief Risk Officer there. I'm from the financial services industry. So for obvious reasons, data protection. Thank you for arranging this. 3 or 4 questions, and I thought the AMEA panel here can answer. One of the aspects of the DPPP talks about, personal and domestic data not being purview to this act. I'm not very clear what that means, and maybe you touched upon it. For example, if I book some food on Swiggy, I'm giving my address and phone number. Am I giving personal data, and that's outside the scope of this? Tomorrow, Swiggy can call back and say, why don't you order a biryani again? So that's number one. Then in which case, all of these become true, which is posting, if I'm couriering something through Blue Dart, or if I'm, sending something to somebody through a certain carrier, and they use my address for whatever reasons. Essentially, I understood the data to be my identity, which is my personal address. Okay. This is number one. The second part is just answering the point about the legitimate interest in use. You spoke about, the protection of the individual here. I think is the base for the But when you look at it from the organization's perspective, we are looking to see, we've been using data all along across multiple things. Organizations undergo change. Today you're in banking, tomorrow you may be a pharmacy, day after you may be in technical services. But under the overall conglomerate of financial services, there are million services. So if you say legitimate use, today it is selling a credit card, tomorrow it is insurance, day after it could be something that meets your financial needs. So when you say erase the data after the transaction, the relationship does not stop, it continues, right? And this could be true for multiple such organizations, especially pharmaceuticals or any such things. The last question, I'm sorry, I'll keep it short after this, is I think you brought up the point about the invoice. I think Mr. Vijayashankar brought it. The name of the individual is there, but the organization is the one that's raising the invoice. Whose data is it? And in this particular case for the invoice, it's the company that's raising the individual, I mean, the invoice on the individual for payment. But the ownership of that data is on both sides. So who does it sit with and what does it go? I've got a whole bunch more. I'll probably post it on the website, but thank you very much. I'll stop talking.
Mahesh can answer this, I suppose.
I'll take the second one. Second question of yours. I mean, I collect the data for one purpose, very simple, right? You said you wanted to go ahead and develop the relationships for processing the data across your services or your products, right? So, but the question is, are you providing that notification to the data principal? Point number one. And clearly, most, if not all, the data privacy regulations restrict you to go ahead and have a purpose limitation, right? So what data you clearly need to go ahead and define for what purpose you go ahead and process or collect that data, right? So complementary purposes, yes, we can go ahead and process it. But for any other different purposes, it is completely restricted unless and until you provide the notice again and say that this is what the processing entails, and we would process it again for a different purpose. But of course, relationships matter. We can go ahead and certainly provide the notice again. So that is one thing. And the other thing which I would want to touch base is, today we are more information givers, right? We provide information, right? So there is a lot of our data in the public domain. The question is, can I take that data, okay, and process it? Think about it.
Yeah, but data there, which,
Right.
So, yeah, so just to answer the questions that you've essentially put. So, see, the question of legitimate use that is here is for you to essentially determine given, and you can retain the data so long as there's no withdrawal of consent. And it is for you to see that you have the entire process in place when you're holding that data, to see things like erasure of data, manipulation of data, etc. is not done. So tomorrow, if the change occurs, you will have to provide that notice for whatever you're going to use it or process it. So there is an entire situation that is here. And plus, the manner in which legitimate use has been provided here, there is an open-ended interpretation here, though they have set out some specificities. But the first and foremost thing is that when you're giving or you're allowing that data to be processed, you have to give that notice. In that notice, you have to put your use, and you have to use the data you're collecting towards that use. Now, if you're retaining the data and tomorrow you want to use it for something else, you will have to inform them. And the idea essentially is that withdrawal of consent can take place at any time. So that is the thing. But the first question, I think, sir will answer.
Next question.
Okay. Any other question? I've got a lot of questions, so I'm going to now moderate. And Mr. Navi is going to be part of the discussion now. So taking the first question.
Check AMEA whether we have got time. I have got time, plenty of time.
Yeah, okay. Because there's a huge number of them. So the first question is, in what ways does the Data Protection Act promote accountability and encourage organization to implement robust data protection measures? It's from Mr. Tangara.
This act also has this compliance requirements. When we say the company should have organizational and technical measures to be compliant with every provision of this law, which means section 1 to section 44, company should be compliant. Otherwise, the deterrence is in the form of penalty. There is no criminal this thing, but not having appropriate technical and other things which may result in a breach, or it may not result in a breach. In either case, if it comes to the knowledge of the Data Protection Board, they can impose a penalty up to a certain level, which need not necessarily have a ceiling of 250 crores or even 500 crores. It can be more than that. So that is the only deterrence. Otherwise, compliance has to be documented. And when a data breach happens or the DPP questions, you should be able to prove that you are in compliance. Yeah. Next.
Next question is on whom to fix responsibility for data leakage when the same data has been provided for different purpose. So
yeah, every data fiduciary is responsible for the data which he has collected. And if the data has gone to multiple things, you have to look at the source of data breach, and whoever, wherever it has breached, that data fiduciary will be responsible.
yeah. So Rohan, this is for you. What measures does the Data Protection Act put in place to ensure sensitive data is adequately protected?
At present, the Act does not directly address a blanket protection for sensitive personal data. In my opinion, that's a concern. And I'm sure it will be addressed by subsequent regulation. But it does address the question. There are two aspects which it does address. One is children's data, which is a certain subcategory of sensitive personal data, which at least it identifies the need to regulate and creates and assures us that we will provide the regulations for. At least it requires verifiable consent of the guardian of a disabled or disabled person or a minor. The other aspect is, of course, what something we already discussed: significant data fiduciaries. And one of the elements in determining what a significant data fiduciary is determining the nature and sensitivity of the data involved. The third thing, which I think the Act does, which concerns me a little bit, but at the same time, at least it's helpful from the perspective of providing a heightened level of protection for financial information, at least, is that the Act does not override the existing regulations which have been put in place by various financial regulatory bodies, such as the RBI, the SEBI, and such like, which are, I would say, responsible actions taken by them to protect individual financial data in this kind of sensitive age. So I think while the Act itself doesn't directly address sensitive personal data, it at least allows for the introduction of regulation, which does.
Thank you. So there's a question here. We do have fraud control unit in an organization. Will it come under employment purpose for no consent? So I think what you're trying to essentially say is that will it fall under the exemption, correct? So the idea of the fraud control unit does not come under the employment purpose, because that is an what do you call standard operating process that you've essentially provided. So the exception that has been provided for employment use is with regard to processing your data with regard to what do you call all the whatever the company is essentially providing. So if I could give an example, it is like your ESOPs or any of your employment requirements. But where essentially it could affect it is with regard to if there is what you call a wrong happening that is essentially happening. That time when your organization is running that process, they can use the what do you call data that has been collected. I think Mr. Navi wants to add something to that.
There is exemption available for the information security or interest of the organization, including IPR and trade secrets. Under the employment, these are not exempt from the, there is no protection as far as the employee is concerned. Okay, the organization can do surveillance, they can do some checking on their background verification, all interest of the employer is what mentioned. Similarly, in financial services, if there is a default of a loan, after the default has happened, then whatever data can be collected and processed is again outside the restrictions. So some interest of companies have been taken into account. Yeah.
Okay, this is an interesting question. Maybe you can answer, Anirban. Is the current act applicable for the non-resident Indians or only to the citizens of India, irrespective of where the data is processed? So I think this goes towards the applicability that is there. So any foreigners' data being processed in India doesn't fall under this. But if the data is processed, so even if it's NRI data, if it's citizen data, if it is processed abroad, if it is to be used in India for a particular purpose, then it falls under this. Otherwise,
Yeah, I think that's right.
So that's essentially it. Sorry, Anirban, I stole the thunder.
No, that's fine.
The next question is, certain retention periods are pronounced by, so this is on retaining of data. So they want to know whether or not we mentioned the retention period while taking the consent, correct? Yeah. So
It has linked to the purpose, just link it to the purpose, and that will automatically take care of the retention period. If the consent is a recurring consent, it may go for a longer time. If it is a single purpose, this thing, it will end there. So for KYC, if you want to have video, that is only for that time when you take that, complete that onboarding. Afterwards, purpose is over, retention is not there. Okay.
So can you elaborate on the provisions related to data breach notification? How do you encourage the organizations to take swift and responsible action? I think 250 crores would be sufficient for doing the swift and responsible action. But yes, Rohan, you want to take that?
Yes. Sorry, if you could just tell me the question again.
I think it's very simple. She just wants to know what needs to be provided in that notice. And which essentially, and how they must go about it in the notice. So if there's a breach, how do they essentially notify it?
Oh, I see. Okay. No, so there is a requirement in the notice to include a specific methodology for grievance redressal. And there is, in addition to merely appointing a grievance redressal officer, now you need to give the data principal a mechanism by which they can address those grievances. So I think the privacy notice, at least there are 3 key factors there. One of those key factors that should be in a privacy notice is grievance redressal. And if I may just step in for 1 second, just say one more thing about the privacy notice. On a certain level, as far as a lot of the fundamental level of compliance for most companies is going to be that privacy notice, because they have all been used to a certain paradigm where they post a certain privacy policy on a website, and they hope that that is sufficient to satisfy their requirements for compliance. This particular legislation does make it a little more granular, in the sense that the privacy notice needs to be provided at the same time as or preceding the collection of the relevant data. So we are now going to have to figure out when the privacy notice is, like, for example, the one on your website, which is there for general purpose users, will not be the same thing which you'll want to provide to somebody who is going to sign on to your services. So now privacy notices have to be tailored for particular purposes. So it's not a direct answer to your question. It's a little supplementary, but I thought it's worth addressing because this is going to be one of the things which everyone is going to try and figure out on a very immediate level.
So the next question is to Mahesh and Anirban, because I think this is more to do with dealing with the data. What role does transparency play in the data protection, and how will it empower individuals to have more control over their personal data?
Well, I think for any business or for any organization, it is really important that they be honest, open and honest with their customers, or in this case with the data principle. And this is exactly what transparency principle talks about. Whatever the data fiduciary have mentioned in the processing or in the processing notice or in the initial notice or in the privacy notice, they stick to exactly to that. Like we have discussed a lot, legitimate interest, they stick to the legitimate interest, while processing the data. And in case of any other change in purpose or means of processing, or any new way they want to process the data, they give the user relevant consent or relevant notice and option to consent. So I think that's where the transparency comes, and it will help the business, to be honest, to if they comply to that, implement this culture, then they will get more customer base. Yeah.
On a lighter note, transparency sort of helps build relationships. If I could go ahead and say that, right? Aligning to somebody who was saying, right, how do I go ahead and build relationships actually? So the reputation of the organization comes into play as well, right? So.
Yeah. So the next one is actually for you, Mahesh, because we discussed this. So I thought nobody better than you. It falls in this. So in what ways will this act address the challenges posed by the emerging technologies like AI, biometrics, IoT?
Very interesting question. Again, I go back to my first comment, the source of the data, right? So I wanted to go ahead and ask what is my source of the data? Very question. If I get an answer, right, as to where my data source is, the other point is once they process the data, right, what happens to the personal data, to the non-personal data as well, right? So one thing is, apart from the source, right? So we have to go ahead and bring it back to the customer, right? In a structured or unstructured format, in a contractual compliance, right? We delete it, we structure it, giving it back to them. So again, source of the data. I don't want to go ahead and give something from what we do as an organization, but I question the source of the data to our data sciences team on how they build the algorithms and the models, right? So how effective is the security? How effective is the privacy, right? And how effective is the compliance on these algorithms and the models as well, right? So that is one thing which I would talk about.
Mr. Navi, this is essentially for you. With the rise of global data flows, how does the Data Protection Act align with the international data protection standards and regulations like GDPR?
GDPR is a different law applicable to the EU data. This is a different law applicable to the Indian data. So the two are different. Two will stand on their own. And we have to develop our own standards for being in compliance with this. That is what FDPPI is doing with the Personal Data Protection Compliance Standard of India. Okay, there is no time to talk about it, but those of you who are interested should explore what FDPPI is doing in terms of PDP CSI, which includes ISO 27701 kind of best principles within this, and focused only on the Indian requirement. And just before we wind up, I want to remind everybody that there are a lot of questions. If you see the bunch of papers she is holding, there is endless questions and very good response from the audience. I am not seeing the audience. It is very clear that they are all very actively involved. Today they will not be satisfied with all the whatever we can do. But look at continuing your say questioning and getting the answers. We are also having our own training programs. Please explore that. I think it is essential. I'm very happy with the kind of questions which are flowing in, actually, like one after another. Yeah, go ahead.
Sir, if I may add something, I think everybody present here is going through a lot of programs, a lot of trainings, newsletters regarding to the new bill. But I think what every organization need, definitely after discovering where the data are or what is the source of the data, they need to do an extensive gap analysis to identify where the organization is and where they need to be. I think this is where we do have a have a very good process for the organization. We call it, sir, if you want to have a chat around a few minutes on to spend on our gap assessment, which we can offer. If anybody is interested, please, they can reach out to us and we can definitely go ahead and
Data trust score.
proceed with that. Yeah, the data trust score that we have in place. So where organization can simply answer a set of questions and they can get a report, automated report, which will be analyzed later by Navi sir and other panelists, and organization can get a clear idea where they are standing today and where they need to go. And this is purely a Make in India initiative. And when you get more information from FDPPI, you will realize that it's very efficient when it comes to cost, comparing to the solution which some other providers are providing. So yeah, I mean, visit our website, it's everything there. And if you need anything, Navi sir is there or we are there, just give us a buzz. Yeah, sorry, please go on.
Yeah, so we are essentially now wrapping it up with a rapid fire. But, the rest of the questions we are not going to take up, though I feel that, I have just written an exam. That's how the questions have come out. But some of the questions are quite elaborate, very difficult to get panelists to give you specific answers because, I mean, that's the reason why I'm carrying the act, so that, one can give you the specific answers. But we're more than happy to help you out later on. So let's quickly just give one tidbit for everyone to essentially give, one nugget as far as this act goes. But one particular question that is here is, when is the act effective and is already in effect? Act is not effective. It's just waiting for the presidential consent. So it is still not, it's passed by the Rajya Sabha. It has to go to the presidential consent. So that's where it stands. So it's not in effect. It will take some time. It's not going to be so simple. So we'll wait for that. So Ms. Navi, your inputs towards this as we are wrapping up.
President has given the consent. Now the date of effect only has to be notified.
Okay. So Ms. Navi, will start with you to, sorry, there's one question.
One question.
Yeah.
One last question, yes. Yeah, give the mic. Yes, sir, we already more short, sir. Very short question. Otherwise, they are here even. In fact, yeah, sure.
Now, if these questions are sent to me by MMA, I will answer it and put it on the website so that.
Yes.
Sir, the content of the question is, you are telling the breach of privacy. What I was listening through this presentation is Data Personal Protection Act. Whereas I was going through an article in Hindu, sir, it's I am just shedding a political light of it. Two big countries after the Second World War, their political ideology was different. One country was capitalist, another country was communist. So what happened over a period of time was, when the government was recruiting jobs for individuals in a certain country, and the government had an eye-handedness to do a background verification, what ideology that individual belongs to, whether it belongs to communist or capital. At that time, an individual cannot say, some individuals protested against it. Who are you to question my ideology? But that country said that the war with other countries is based on ideology. I have the right to protect my country's ideology. So that's not a breach of privacy, when it comes under National Security Act and something like that.
I think that's a good wrapping up question. Good wrapping up. So just to bring it to context, what we are basically trying to see is, where does the right of privacy start and where does it end? So the act essentially gives exemptions to the government when it comes to processing of data. It gives exemption on its use. It gives exemption to the regulatory authorities, supervisory authorities. So the jury's out there that maybe the RTI Act is also affected. So that's where you are basically coming in, that when it comes to the government is not subject to, all the regulations that are provided here. But that is one of the greatest critique as far as this act goes. So most probably, my input in this is that this is just the first step. We'll still have to see what the rules say. And we still have the courts as far as interpretation goes. But yes, this act very clearly gives the governmental authority a lot of leeway on how they treat the data, use the data, and also process the data. Mr. Navi, will start with you for the closing remarks on this.
Yeah. One closing remark I would like to say is that this is only a beginning of the discussion. We need to continue. So everybody has to keep themselves open to learning new concepts. There is going to be a series of notifications which the government will give. Maybe those notifications will change some of the perceptions which we have discussed today. So we will have to keep ourselves open to it. What the government has done is we will protect this digital personal data. They have not committed to protecting the privacy. They have only committed to protect the digital personal data in a particular manner. Let us understand that this is the limitation, like the question which you raised now about the political opinion and other things. At this point of time, government has not taken the responsibility to curb those things and other things. So it is left to the Supreme Court in any of the cases to actually come up with its views. We have made a beginning of understanding this new act. And maybe some things which we have said also may undergo a change as we get more clarifications. But generally, we can say that this is a good attempt by the government. And despite some concerns of the privacy activists, at least the companies they can start doing something. And even if they give us 6 months to say 1 year time for implementation, we can try to put together this compliance by design and be ready. I hope there are a number of industry representatives there. I think you please start working on this compliance from today. Don't wait for let the DPP be set up. It will take 3 months. Let the penalties be effective. This will take another 1 year. But setting up a compliance is a very tough job in an organization. It will take time. So the earlier you start, better it is. Okay. Yeah.
Thank you. Thank you so much. We totally run out of time, and ladies and gentlemen, big round of applause to distinguished panelists for the gathering. Thank you, viewers. We have over 730 viewers are watching this. So many questions have come. As I said, we'll have answers to all these questions. It's like Chandrayaan 2, the lander landed so smoothly and not much dust. I think the act will also be smooth and not much dust, and will settle down very soon. And thank you, Navi, for joining us, and the other panelists joining us, Anirban and Avinash and also Rohan. You are separated by distance. Next time when you come, we would like to really see you at MMA Management Center. And we have a digital memento for you. And on behalf of each one of you, what we do a lot of work at with the poor school children. We give them books, we give them a number of support. So on your behalf, this is what we are going to do to all the children from the government schools. This is a memento on your behalf. Thank you so much for really accepting our thing. And because people like you come and speak in MMA, that's the reason we are able to bring in some large number of audience to watch this program. Before I call upon Sridhar to deliver the formal word of thanks, he's the founder of MapTech and also president of DFI. Let me have the privilege of presenting a memento made by children. We do a lot of work, as I mentioned to you, with the school children. This is all made by them, and I'm quite sure it'd be a very pride position for you to showcase in your drawing room. May I request you please step forward and do us honor of accepting this moment. Have a good picture. Thank you, sir. Okay. Come. You know the picture, you know the children, what we do actually. Bring that, we'll have a group picture. They'll also be there. Come to the center. What is it? Yeah, now see that formal word of thanks.
Yeah.
I'm going to leave.
Good evening. I stand before you on behalf of the Foundation of Data Protection Professionals in India, FDPPI, FDPPI.IN, Chennai chapter, to express our heartfelt gratitude to everyone who made this event a grand success. First and foremost, our sincere thanks to MMA for graciously hosting this seminar. Your unwavering support and commitment to fostering knowledge of sharing platforms like this are truly commendable. We are deeply honored to have had the partnership of ISACA Chennai chapter. Your collaboration has been instrumental in amplifying the reach and impact of the seminar. To our esteemed panel of speakers, Captain Kumar, Na Vijayashankar, Dr. Anirban Ghosh, Dr. Avinash, Mrs. Savitha Kesav, Mr. Rohan K George, and Mr. Mahesh Balakrishnan. Your insights, expertise, and perspectives have been invaluable. Your dedication to unraveling the intricacies of the DPDP Act and its implications for businesses and individuals have undoubtedly enriched all our participants. Thank you, and look forward to many more such collaborative endeavors in the future. Thank you.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thanks to all the panelists from my personal side. Okay, we will meet again in some other occasion and continue the discussion. There is so much to discuss anyway.
Thank you, sir.
Thank you, sir. My pleasure.
Okay.
Oh, thank you so much, Navi. Thank you all the panelists. It was indeed a pleasure to have you with us. Till we meet again. Bye-bye. Good night. All the members of ISACA and other organizations. Thank you for joining and looking forward to seeing you more at MMA. Bye-bye. And get home very safely.